do have another academic coordinator who's not here. She lives down in Leicestershire, so it's just the two of us today. And we also had an artistic coordinator who's also not here today, but Chloe's going to talk a little bit more about that later. I'd just like to say, first of all, this is actually quite scary for us because we are academic lawyers, and this is the first time we've ever presented to an artistic audience the work that we've been doing, so a little bit anxious about that. But I'm really looking forward to hear what you've got to say afterwards, and I'm really pleased to see some friendly faces in the audience, and that doesn't mean the rest of you are unfriendly, I hope. I know some of you that are here, which is great. I'm really also pleased to see that everybody has filled in one of the stickers with the, or most of you have filled in the sticker saying why law needs art. And I don't know if that's what you normally do with those afters, but really cool if we could collect them because we're really interested to know what you think, working in the creative industries, what you think law needs art for. So, and more of that later. So this is the Feminist Judgments Project. I'm just going to talk you through a little bit about what the project is and how it started, and why we came to art, and then I'm going to hand over to Chloe to talk about the responses that we've had from people from using art in the project. So, I'm speaking at a very Glaswegian pace, so if anybody can't hear me, I want you to slow down. Just wave and I'll slow down slightly. So, the academic project, Scottish Feminist Judgments Project, is a project that brings together mostly academics, but also some other people working in the third sector, practicing lawyers and so on. And the idea is to take key legal cases and then rewrite the judgment in the case as if the judge had been a feminist, and only using the materials that would have been available to the judge at the time of the original judgment. So it's to try to show that rather than a kind of fantasy island, kind of what would happen if we could just imagine anything, even at the time, the judge could have done something very different and feminist if he looked at things from a different perspective. So that's the idea of the academic project. It's part of a global conversation in the sense that these projects are now all over the world: Canada, Australia, New Zealand, and there's now an African project, an Indian project, and so on. It began in Canada and it's grown and flourished since then. We are the only project so far that has used art, I'm going to say, in an integral way to the project. We can unpick what we mean by integral, whether it really is integral or not. But we're the first project that started to bring on board art into the project to ask about what is law doing, is law just, is it fair, and so on. So the audience we've been aiming at are judicial audiences, student audiences, lawyers. They're the people that we're hoping will go out and buy the book, which is coming out in October. I don't have the copy of it with me, obviously, but we can show you the front cover later. And the art was really part of the idea of trying to reach beyond the normal academic audience, beyond the legal practitioners and the students, to try to reach the public and other sorts of communities outside of the legal community that might be interested in law, but might find legal texts and conversations about law inaccessible, boring, dare I say it, and also something that is just not part of their routine daily lives. So how do we bring those questions about rejudging, re-seeing, reimagining law from a feminist perspective to a broader audience? That's why we started to introduce art. So the three of us have said, Sharon, me, Chloe, and Vanessa, we're the academic coordinators. We also have Jill Henry McNeil, who's our artistic coordinator. We have 16 judgments that we rewrote with 19 judgment writers. And we also had comments on each judgment, and then a reflective statement by the judgment writer about what was the process like of trying to imagine being a judge. That was the academic project. Why did we include art then? Part of the reasons I often say to students and so on is that law is not a sausage-making machine. It's not a machine where you feed in the facts of a particular dispute and out pops the right answer. Because in that machine, a number of different mechanisms that are going on will affect the answer that you get. So it's about perspective. It's about coming to a problem with a particular set of views that you already have formed as a human being, as a judge, as a lawyer, and so on. So it's about different ways of seeing, basically. And art, of course, is a different way of seeing things in law. So the lovely content person who's up, whose name I've forgotten, the fidget tattoos, they're saying about the legacy of language. And one of the things we're trying to do in this project is really think about the legacy of legal language and what that legacy does in the real world. So these quotes are this one from Joan Key, and this one from Ora Ben-Dor. These are the theoretical kind of grounds of lawyers thinking about why art is important. Those are the kind of big conceptual thoughts and theories around why law might need art. But one of the other reasons we wanted to bring art into the project was, as feminist academics, what we wanted to do was challenge the idea that the only way to address and tackle and engage with law was through the same sorts of tools that were already being used by a patriarchal legal system. So it's the Audre Lorde quote, "You can't dismantle the master's house only using the master's tools." We wanted to use other tools other than law to try to undermine this idea of the importance and centrality of law. So today what we're going to do is talk a little bit about one case. I'm aware that I've only got a few minutes left. I'm going to hand over to Chloe. But one of the cases in the collection is called Trudi against Her Majesty's Advocate. And the case facts were quite distressing. It's about a case where the ex-partner of a woman killed her with a hammer. He claimed he did so because of jealousy, because she had been sexually unfaithful to him, even though they were no longer together as a couple. And the court accepted this plea of provocation by sexual infidelity. And what that plea does, from a legal perspective, is it reduces your charge from murder to culpable homicide if it's successful. So in other words, no longer a life sentence. The court can give you a discretionary sentence of any length for culpable homicide. So the court accepted that this was a valid plea, this provocation by sexual infidelity, and that plea still exists today. So that was one of the cases that we took, and we rewrote the judgment. I can see people saying wow at the back. We say wow too. This is one of the reasons we wanted to do this case. So one of the things we did was we asked the written judge, the feminist judge, to rewrite the case, and she did three things. She challenged the narrative of the case by including more of the story of the victim that we knew about from other sources that the court would have known too. Like, for example, the murderer had stalked this woman for a long time. She has several injunctions against him. She'd been subjected to domestic violence. All of that was known to the court. It doesn't appear in the written judgment. So we wanted to change the narrative of what happened by including that in the rewriting of the case. We changed the reasoning. Claire McDermott, who wrote the case, changed the reasoning by looking at the case law, the history, and reinterpreting it. And she also changed the outcome by saying, this is no longer a valid plea under contemporary Scots law, or it shouldn't be a valid plea under contemporary Scots law. You won't be able to read those at the back, but what we did then was we asked one of the artists, we had 7 artists in the project, to respond to the cases in the project or the project as a whole, and one of them responded to this particular case by writing 4 poems about it. Her name is Jay Whittaker. She just won the Saltire Award for Poetry this year. She's a really excellent poet, and you won't be able to read that from the back, but I'm just going to play you quickly the first 2 poems. They're very short, so hopefully you'll hear them through the speakers. The first one's called Provocation, and the second one called Not Here. So this one's called Provocation. This is a found poem, which means she only took words from the judgment itself and used those to create this piece of work.
Provocation. Ordinary wickedness of heart slapped her. Reasonable frenzy. A mere man lost control. Claw, hammer, killer, precisely. Struck her. Brute retaliation. Overwhelming, blunt force. Facial bones. Tooth sockets. Act faithful. 7 blows. Act depraved. A disproportionate fidelity.
So those were the words that were taken from the judgment and then put together into this poem. Lots of people, and Chloe's going to talk about this, but lots of the people who've come to see our exhibitions of the poem are really affected by the poems. I'm still really affected by the poems, even though we've read and heard them many times. And the second one is also about the woman in the case, Marla McKenna, her name was, who was murdered by her ex-partner. So this is called Not Here.
Not here. Not in this wall of words, considered deliberations of 5 judges, muffling argument, convoluted phrases. Not in the pathologist's report, the facial injuries the worst you'd ever seen, multiple comminuted fractures. Google it. Shudder. Look her up, find her sliding out of snaps like any one of us, not sensing we are mortal.
So again, just to link back to what I was saying a moment ago, one of the ideas of rewriting the case from the academic point of view, but also the artistic point of view, was to try to have Marla McKenna's story more central in the rewriting of the case, because it was completely lost from the original judgment. So I won't play you the other two, but one of the other pieces of work that was created for this project by a really remarkable composer, Alison Burns, was a piece of music I'm about to play you a little clip of. She took some of the words of Jay Whittaker in one of her poems and translated them into Latin, and then created a kind of hymn choral work from that. And I'm just going to play that to you, a little bit back to you now. It's about 4 minutes long, so I'm only going to play the first 20 seconds. So this is called Absentia, and it's based on one of Jay Whittaker's poems. Cases in the project. We'd be really grateful to hear your thoughts on this after we finish speaking and we have a chance to discuss it with you. And I'm going to hand over to Chloe to talk about how other people who've come to see the project and see the art have responded to the way that we have used art in this project.
As Sharon said, I'm going to be talking a bit about the way that people have responded to these artistic works. I'll also share some of the insights from the judgment writers and our creative collaborators when it comes to their experience of being involved, where it's relevant. So really what I'm going to be doing is talking you through some of the ways that the responses we've had suggest that perhaps some of these aims that Sharon mentioned at the start have been, in inverted commas, successful from our point of view. So how has the art helped us kind of open the law up to critique, show it to be something other than a sausage-making machine, elicit different kinds of responses. But I'm also going to then talk a little bit about some of the challenges that we encountered while trying to do this sort of work together, including some practical challenges as well. And the hope is that this might also be useful to people in the room here who might be thinking about getting involved in collaborative work with legal professionals or generally anyone from outside your kind of area. So these are some quotations that highlight this theme of opening the law up to critique. Sorry, this is quite text heavy. It's really just to illustrate the points more generally than maybe. So the first one up there is from an audience member who's saying this, who's I think reflecting this point about law being perceived as neutral and objective and somehow, like a sausage-making machine. She says, or he said, I've always considered the law to be fairly straightforward, and he was genuinely quite startled to see how much perspective can actually change the way that law is applied and how people are affected through law. The second two quotations I think highlight this point about the art kind of creating a space to critique the law. So seeing how law is very different from justice how perhaps sometimes the law fails to really address the issues that it's supposed to be helping to fix. So this is the quotation, that's second on the slide is about the poem you heard there, the vow poem, Provocation. And this person who read the poem felt as though the contrast between the legal concepts and the violence was really striking. And I think this contrast is something which also comes out in some of the language that Jay chose to pick out. So this idea of a reasonable frenzy, right? That just sounds really bizarre to us. How can a frenzy be reasonable? But that's what the law is actually asking us to think about and endorse. This last quotation is from the judge who wrote the feminist rewriting of that case. So that's Claire McDermott, who Sharon mentioned. And I think what's interesting about this quotation is she says, even for her, who's very familiar with all this language, she's familiar with the case, seeing these poems made her think about the case in a very different way, especially the vow poem, I think, a different form and rhythm which had become familiar through legal writing. So it's making the familiar strange, and I think doing that helps us to get a kind of way into critiquing that thing, whatever it is, law in our case, which has become very familiar. As I said, I think the other thing that's been really striking for us is the way that the art has elicited not just responses from different kinds of people, but different kinds of responses, really visceral, affective kind of responses. And I think this is extremely important given how often law tends to abstract away from those kinds of issues. It presents things in a very formal, kind of dry way. And I think that's one of the amazing things that's come out of this project. You can see the quotation, some of you anyway hope you can see them. The first one is referring to appreciating the human cost of these legal decisions. So who is affected? How are they affected? These are things we ought to be caring about if we care about justice. This point about getting caught up in the arid legal detail. Okay, again, this is kind of referring back to one of the quotations Sharon had up earlier about how law sometimes just misses that entirely. It doesn't do a good enough job of capturing it. And I think this point too about bringing out the perspective or the life story of the person who's been affected by the legal decision. Okay, so here we've got a reference to the fact that this law is supposed to somehow resolve these issues, but it just can't, okay? It's just not possible. It can do something to help us, but it's not the full story. The final thing I want to highlight here is just how often people felt provoked into making comments that suggest this work could help us in trying to think about how law can be different. So mobilizing people, galvanizing them around the idea that law is something we should all be thinking about and thinking about how it could be better. So I really like this quotation here. Thinking about feminism is something that we actually use, something we do, right? We can create through feminism. Not just something we talk about and write about, it's actually something kind of active that we can use to our advantage. I think also what this has helped us do is to create what we've been referring to as kind of different communities of understanding. So this point about accessibility in law, people generally maybe can't get into it if they're not within our circles, if they're not academics or if they're practicing lawyers. This has opened up law to critique, and it's meant that we are able to also get a sense of how different perspectives could be fed into law, right? How different points of view could be used in trying to reform the law to make it better. One of the things, though, that I think was very interesting for us was that the issue of inaccessibility was still kind of there, right? So this is something I'll talk about more in the slide I'm about to move on to, but this point about law being intimidating, technical and expert and hierarchical remains even after people have come and seen the artwork. So there's something still, I think, interesting about how our attempts maybe just highlighted how inaccessible law might be. So lots of text here again, apologies for that, but here is some of the challenges we faced, okay? So we really enjoyed the experience, and I think it's been very fruitful, but there are things that we possibly would have done differently, and I want to just be honest about that because I think it can be helpful to do so. So the first quotation is from one of our creative collaborators, and I should say we did, I think, go to quite a lot of effort to try and make sure that our creative collaborators and the legal collaborators talked to one another, and we had a number of events where everybody was present. But it became clear after the fact, sadly, that perhaps we didn't do quite enough to make sure that those who didn't have a training in law almost had enough of a translation provided. What are these issues that we're talking about? What are the terms that are being used? One of the creative collaborators unfortunately felt, I think, a little bit alienated through the experience of coming to those workshops. So she's mentioned how she felt isolated and stupid because of her inability to understand what was going on. And she also felt that needing to engage with these legal words was somehow quite stultifying, quite kind of restrictive. It made her feel a bit inhibited, I think. However, I think it's fair to say that also some of our collaborators felt this was a generative kind of experience. They thought and reflected deeply on how they felt perhaps alienated and tried to work that into their creative responses as well. The last quotation is from the same creative collaborator who said also she's going to use this experience in her own collaborative work. She can think about how she was on the receiving end of feeling a little bit perhaps left out, and so when she works with community groups, she's going to try and make sure that doesn't happen to them as much as she can. A few other thoughts about how we went about this. This is the point Sharon raised about whether we are in fact collaborating or not. What does it mean to collaborate? This is a quotation from one of the creatives. We felt we were guests in your world, suggests something of a separation still. And then the second quotation is from one of our legal judgment writers who said, the longer quotation is, nothing about the artwork really changed how I did my part of the project when I was writing my judgment. It was great for publicity though. And I read that and part of me sort of just cringed internally because I thought, this just feels very much like we're maybe being tokenistic, perhaps we're being a little bit instrumental in the way that we are showing this artwork. And I should say, I don't know if anyone here works with academics much at all, but in the UK there's this big drive towards showing that our work has inverted commas impact. And one of the really sexy ways to do that now is through interdisciplinary work, and I think that does maybe just question what we were doing, whether it was actually collaboration at all. I'll end now just on a couple of thoughts about some of the practicalities. Some of our creative collaborators felt that because they were dealing with real people, so especially with people who had passed away and who had passed away recently, like the victim in the case that Sharon described, Marilyn McKenna, they were quite concerned about how they could do that in an ethical kind of a way. And I think, again, this might be something that resonates with people in the room. And they found their sort of way through doing, to do that well was to try to abstract away from the details of the case and really just think about how they felt when they heard about the case. So something about their emotional response to it that other people might share. And I thought that was saying how law tends to try and abstract away from people's life stories. But here there seems to me like an abstraction that's somehow more humane. It's trying to be protective of the person at the heart of the case rather than erase them from the picture altogether. Very briefly on recruitment, we did this in a very ad hoc way. We didn't know this would become such a big part of our project, and so we kind of, I think, a nice way we described it, euphemistic way maybe, is that it was an organic process of snowballing. We should probably have been a bit more thoughtful and maybe more transparent, perhaps recruited more openly. And that's something, if we do this again in our academic careers, we'll probably try to do. Questions of payment as well. How do you try and make sure you're paying people you work with fairly? We are asked to do research as part of our jobs, as part of our salary. Part of our salary involves producing research. We didn't really, at that point, have much guidance at all on how much we should be trying to pay our creative collaborators. We had some help through Jay, but the good news is that our university has now put together guidelines on this, so that's a positive. This last point is something that perhaps you guys can help us with. We've been thinking a little bit about how we leave audiences when we deal, especially with these really challenging themes, and how to leave people feeling maybe empowered, but also like they can continue the conversation. So if you have any tips about that, we'd love to hear them. I think I'll stop because we have other artwork in the show, but possibly that could be done in the Q&A. So thank you for your attention.